Right.
Our systems go. Good morning. Welcome to another exciting meeting of the Board of Environmental Control Board. Is there a motion to adopt the minutes of the June 30th meeting? One abstention? Oh, okay, so it's unanimous. What the minutes say is, what happened?
One abstention.
One abstention. One abstention. The first item on the agenda is a resolution to say that we concur with the Department of Finance's efforts to collect debt that's owed to the city of New York. That's a consequence of several years of ECB hearings. The outstanding debt right now is, I believe, in the neighborhood of $1.5 billion. Some of it obviously will never be collected because some of those people are dead for no other reason. And there's no estates and there's a whole bunch of other reasons. But the feeling is that if they offer sort of an amnesty, waiving penalties and interest and stuff like that there, some folks will come in and take care of business. Then the Department of Finance can clean its books, and we can start fresh again until we get to another $1.5 billion and move the whole thing all over again. The authorizing legislation, as will be explained in a second, calls for, asks for a resolution from us concurring that it's a good idea for the city to offer a deal and to collect the debt. And it'll be explained in a second.
So Simone Saloom, Assistant General Counsel with Oath, and as the Commissioner explained, the local law 45 requires that we pass this resolution in order for the Department of Finance to establish this program. I'll read the resolution, and if anyone has questions about specifics with the program, I believe that a representative from the Department of Finance is here and can answer kind of those more specific questions. So the resolution is that pursuant to local law 45, which establishes a temporary program to resolve outstanding judgments imposed by the Environmental Control Board, the board hereby concurs the Commissioner of Finance establish a temporary program to resolve outstanding judgments for a 90-day period to be effective during the fiscal year that commenced on July 1st, 2016. This temporary program will permit respondents who are subject to default judgments to resolve those judgments by payment of base penalties without payment of default penalties and accrued interest. It will also permit respondents subject to judgments entered after an adjudication and finding of violation to resolve those judgments by payment of 75% of imposed penalties without payment of accrued interest. Does anyone have any questions? Yeah.
Hi, Elizabeth Mauer, citizen member. I'm just wondering, I take it that there was a previous amnesty back in 2009, I think. So I just wondered what the success rate of that was. Was there a lot of collection as a result of that?
My understanding, I don't know the success rate, but I am Dara Jaffe from the Department of Finance from Legal Affairs. It's my understanding that we collected about 14 million, and that I can get a more exact number if you want. That was
14 million out, I mean, what, in comparison to what amount of debt?
whatever the existing debt number was at the time. I don't know.
My understanding is that that was pretty dismal compared to the amount of money that was owed. But I believe EOF this time around is going to more aggressively advertise the program. And hopefully they'll collect a little bit more than that, but one way or another, at least it cleans up the books and they can discharge a lot of uncollectible debt. It looks like the city's in the hole for $1.5 billion, when in reality we know that's not really true, because a lot of that is uncollectible stuff. businesses that don't exist anymore and people that don't exist anymore, and a lot of stuff like that there. But last time around, it was nothing to brag about from what I understand. It's better than nothing. It's 14 million bucks more in the piggy bank than they had before.
I'm just wondering if it encourages people, you know, to just wait after this period ends, and then there's additional judgments or default judgments. Does it encourage people to just sort of wait for the next one of these instead of paying the judgments in a timely fashion?
That's the same question that always occurs to me when I hear about amnesty programs.
I think if it were more used last time around, maybe there'd be an argument. But since it seems that not a lot of people used it last time, I don't think a lot of people are sitting around waiting.
And also,
for it
I
to
just
come
wanna-
around.
Well, this time, you mean?
Yeah, I just want to add that it seems like the enforcement agent, Amy Slipka, the enforcement agencies are taking a more aggressive path also to see that these debts are paid, because they're not going, the building department's going to start looking at this as far as issuing permits. So things are changing within the enforcement agencies to make sure that if you're found in violation or you receive a violation and fail to show, you will pay that penalty. That's all.
Yeah, something that's not part of this legislation, which was legislation earlier this year that really didn't come across our table because didn't really relate to us directly, is new legislation that says that certain categories of people who have licenses or need permits from the city who have not paid their fines to the city, and there's a whole list of categories that they fit into within an appropriate period of time, will either have licenses suspended or revoked, or they will be precluded from getting like a building permit until such time as they take care of whatever it was that they had to take care of. So I think this is part of that package, although it seems to be discreet. And hopefully that will encourage people to do the right thing. Preferably not do the violation in the first place. Silly concept.
The language is on the front, Shimon Brown, Department of Building. The language is on the front of the violation that was part of that. So the public is already aware of it, so that's enough of not just, many agencies are taking it.
You're talking about the new summons forms.
Right, I remember that. And the Department of Finance is in favor of this?
Yes.
It's their idea.
Is it their idea? Okay.
Any other questions? Is there a motion to tell the Department of Finance that we think this is a lovely idea and they should sally forth and do their thing? I think it's unanimous. We should do a motion to invoke my real estate. Something with the first part. There is a proposed rule to repeal, for the repeal of littering, sweep out, throw out charges from the sanitation penalty schedule. Where is it now? That is the question.
Good morning, Elaine Balsom, Deputy General Counsel for Oath. This proposed rule is part of the Criminal Justice Reform Act that was passed earlier this year. There are several pieces of the act. One of those pieces, Local Law 75 of 2016, made changes to the administrative code regarding some of the sanitation provisions. Section 16-118.1, which covers littering, sweep out, and throw out, was split into two sections. So there's now a section 16-118A, which covers littering, sweeping, and throw out, and there's a 16-118.1B, which covers spitting. In addition, there was a carve-out made to noxious liquids, which is section 16-118.6, for public urination, which is a subset of noxious liquids. So these new charges, the new ones, and the littering, sweep out, and throw out charges are going to have new penalties. The first offense penalty is a flat penalty of $75. The second offense penalty is a range from $250 to $350, and the third offense penalty is $350 to $450. The default penalties are capped at 150% of the base fine. Without a rule setting the default penalties, that would make the default penalties the 150% of the higher end of those ranges, because New York City Charter 1049A says that upon default, the board will impose the maximum penalty under the law. Because the current charges for littering, sweep out, and throw out in the penalty schedule do not reflect these new penalties, we are asking to repeal those charges, and that's what this rule does. I gave you a new copy this morning. The law department will be certifying this rule. It's just had a couple of grammatical changes and then the addition of a chart concerning what accessibility options are available at the site of the public hearing. Questions?
Elizabeth Now, our citizen member, and I'm sorry, I got a little bit lost in what you were saying, but these penalties are now in some other code? Or
They are in the administrative code.
they're just in the administrative?
That's correct.
Okay.
They preempted us.
And I should actually say that 150% of $75 is $112.50, but we can't program change, so the default is going to be 112.
Forget
So-
about that.
I think it's kind of innocent to figure out how to program our computers. I'm sure they can do it to the 10th of a pen. Any other questions? Any discussion? Is there a motion? Well, considering everybody's making the motion, I guess it's unanimous.
Thank you.
Thank you. Now, DEP will present cease and desist order motion.
Okay, thank you. Good morning. Russell Bucunes, Assistant Counsel with the Department of Environmental Protection. This month, DEP is requesting that the board issue cease and desist orders in 28 cases involving failure to install backflow prevention devices. In each of these cases, the building owner has been ordered to install the device and has also been issued a notice of violation for failing to install the device, which has been adjudicated in violation. They have still failed to install the required device. So in each of these cases, the department is asking the board to issue an order to cease and desist. These should all have been dated for today instead of June 30th, because the batch for the May meeting didn't get approved and had to be moved over to the June meeting. These didn't get redated, so they have last month's date on them. They should have today's date on them. So the department is asking the board to approve these 28 requests collectively.
Any questions? Motion? It's unanimous with one
Okay, next.
exception.
Next, DEP is asking the board to approve a cease and desist order in the matter of Zion Farm LLC, which is the owner of a restaurant located at 55 East 59th Street. This restaurant has some grease traps. However, upon inspection, it was determined that the existing grease traps are not properly equipped with the required baffles and vents. In addition, it was determined that a number of items of equipment in the kitchen, 3 floor drains, a 3-compartment sink, 2 woks, and a 1-compartment sink, all lacked required grease interceptors. A series of orders and violations have been issued to the respondent to correct these conditions. There has still been no compliance, and in view of the series of enforcement actions that have been taken and the continuing failure of the respondent to comply, the department is asking the board to issue an order to cease and desist.
Questions? Motion? It's unanimous with 1 abstention.
A wok has a grease?
Yeah, actually, I have seen it before. Apparently, it's a separate station where they use the woks, and the grease from that separate wok station goes into a drain for that section of the kitchen. So,
Must be one serious walk.
yeah, I actually don't know what this does business as. I don't know what the restaurant's name is. I didn't look it up. But. Okay, next we have a request for a cease and desist order under the noise code for FASTA NYC LLC at 36 St. Mark's Place. This location has been cited for noise from the kitchen exhaust 3 times this year. They have not complied by correcting the condition. In view of the repeated violations and continuing failure to correct, the department is asking the board to issue an order to cease and desist.
I actually had a question about this one. How many violations were there? It seems, I think the affidavit only described 2, so I.
Normally, and going way back, the required number of violations that need to be issued before we ask for a cease and desist is 3. So for noise and air
Right.
conditions, that's what we've been going with for a long time.
Okay, I think that the affidavit in support only mentioned 2 violations.
Well, the affidavit in support only mentions the original violation
Right.
and the most recent inspection that resulted in the
Okay,
violation.
so it doesn't reflect all the different
Yeah, it doesn't
violations.
refer to all.
Okay.
Any other questions? Is there a motion? I think it's unanimous with 1 abstention.
Okay, the next one is a little bit of an unusual one because it involves music from a commercial establishment. We usually do not ask the board for cease and desist orders for music from commercial establishments because it is so easy for them to replace the equipment. And since these are equipment specific, one of the ways that you can correct the condition is to just replace the equipment. In the case of music, all you have to do is unplug the amplifier and put a different one in, or take down the speakers and put up different speakers, and technically you've removed the offending equipment. So we usually don't ask the board for cease and desist orders for music. However, in the case of Lucky 7 Restaurant and Bar at 1447-1457 St. Nicholas Avenue, we have cited them for excessively loud music from this location 4 times in the last 2 years, including 3 times this year. There are also 2 violations that are more than 2 years old. So they have a total of 6 violations. They have not paid any of the penalties, so they have nearly $20,000 in unpaid penalties. And at this point, instead of just continuing to issue summonses, This one has gotten to the point where we felt it was worth a try to at least have the board issue a cease and desist order to try and get some kind of response from this business to the fact that they are continuing to plague their neighbors with excessively loud music. So although we usually don't request cease and desist orders for this type of violation, in this case, due to the long history of repeated violations and the continuing failure to comply, we are asking the board to issue a cease and desist order.
Any questions? Motion?
And finally, we have a request under the air code for Acropolis Gardens Realty at 2105 33rd Street in Queens. The situation here is that they have a certificate of operation for their boiler, which has been expired for 6 years. They do have a certificate to use number 4 oil, which is currently permitted. This is not one of the ones that relates to the use of number 6 oil. However, we have cited them for having this expired certificate 4 times. One of the reasons that we've done that is that this particular building has been the subject of repeated complaints regarding smoke from the chimney. We have not yet been able to actually catch the chimney smoking, but we've been doing inspections in response to complaints. And so when we go, we haven't been able to see the smoke, but we issue them a violation because they still haven't renewed the certificate of operation for the boiler. And since we are still getting complaints and they still have not renewed the certificate that has been expired for over 6 years at this point, 7 years actually, it's from 2009, the department is asking the board to issue an order to cease and desist in the hope that that will provoke them to renew the certificate, and in order to renew the certificate, they will have to pass certain emissions tests, so they would have to fix the smoke problem that the neighborhood is complaining about. So we are asking the board to issue an order to cease and desist.
Any questions? Motion? Unanimous with one abstention.
Thank you very much.
I have a question.
Yeah.
Relating to Lucky 7, can't the city take advantage of the nuisance abatement law? There's some, after a chronic problem like that, to simply padlock the premises?
I don't know that we would have the authority to do that. The police department might have the authority to do that. I don't know, since this is not generally the type of noise complaint that NYPD responds to.
I was thinking
whether
like,
they've done any inspections here.
I was thinking like the Office of Special Enforcement.
Yeah, I mean, we do participate with them in the march details, which focus on the nightlife heavy areas, but I don't know if this is located in one of those areas.
It's kind of frustrating for some outfit like that to be basically torturing their neighbors like that consistently. That's what.
Yeah, I also don't know how they.
That's broken windows.
How they renew the liquor license with these noise violations either. But,
Okay.
yeah.
Wondering. Is there a motion to adjourn for executive session so we can?
Wait.
Oop, I missed something?
Preceding reports.
Oh, pre-selling reports. I'm so eager for the executive session. My favorite stuff.
Good morning, I'm Kelly Corso, Assistant Director for Adjudication for Oath. We have 10 pre-sealing reports today and 1 full sealing report. The 10 sealing reports consist of cases involving 1 sewer code violation, by backflow violations and for air code violations. The sewer case, DEP recommended that the proceedings be discontinued because records have shown that the respondents have come into compliance with the sewer code. On the backflow and air code cases, the DEP recommended and the hearing officers agreed that there be no sealing or other action based on the evidence of the respondents' compliance that was presented at the hearings. So that's the 10 pre-sealing cases. The one post-sealing case we have is pertains to a noise code violation, and the respondent in this case is New York Mart Street Inc. And the premises involved is located at 128 Mott Street in Manhattan. This respondent received a summons in October 2014 for operating a kitchen exhaust system in excess of 42 dBA. This summons resulted in a stipulation and an order of compliance forthwith. An inspection report following the issuance of the summons showed that in August 2015, respondent had not complied. The board approved a cease and desist order for this in October 2015, and the respondent did not appear for the October pre-sealing hearing, and subsequently DEP sealed the equipment. Since that time, there was a post-sealing hearing on July 5th of this year, and at the hearing, DEP submitted a inspection report from June showing that the old kitchen exhaust equipment had been removed and new equipment was installed. And DEP's inspection also showed that there was a noise reading taken, and it showed the new equipment was in compliance with the noise code. And DEP is recommending, and the hearing officer agrees with that recommendation, that there be no further action and that the equipment remain unsealed. That's it.
Unanimous with one. Okay, thank you. Now we'll go into the second. If you concur. We're now back in the public session. Is there a motion for discussion? Is there any discussion on appeals? Is there a motion to accept the appeals? It's unanimous. Is there a motion to go out any good weather? Whether, I think we're adjourned. Thank you.